Okay, we're visiting with Mr. Eric Martin again. He's our gentleman who has studied law for a long, long, long time. He's told the judge he knows everything that he needs to know so he can be his own attorney. I don't know how many times this has been. He's been in front of the judge. He's in front of Judge Slaven today. Judge Slaven don't play. And Mr. Martin is for sure that he knows what he's doing, and we're going to see if he really does. So sit back, relax, and enjoy.
Ms. Manarino, good today, date and time set for a settlement conference. Parties have an opportunity to discuss the matter.
Good morning, Your Honor. Angela Mandarin on behalf of the people. Your Honor, I did have an opportunity to hear Mr. Martin's position on the issue while we were in the breakout room. He requested that I dismiss the case. If people are unwilling to do so, and would ask that the court set this for a trial.
Okay, so it's a settlement conference, and naturally, Mr. Eric Martin wants the case dismissed. She's not going to do it, so we're going to head to trial. This ought to be fun once we get through this awkward settlement conference. Let's continue. Enjoy this, folks.
So we've already had the motion to dismiss. Get the this is the motion on the demand for the body cam footage. Is that correct, Mr. Martin?
Yeah, that's what.
Okay, so Mr. Martin has put in a motion and a request to the court for body cam footage. So it appears to me that Mr. Martin has accepted that the judge has established jurisdiction over him. He's filing all these motions. So there you go. At least we've got that issue out of the way. Or do we?
The things that recently filed among some others. Yep, go ahead.
Cam. All right, so I will enter the order for discovery, and then Mr. Martin, you can request that from the, once you get a copy of the order, you can request that from the PD.
Well, congratulations, Mr. Martin. You have just had your motion granted. I bet you're just overwhelmed with joy and ready to go. Let's see.
Now, as far as the moving forward goes, because obviously Mr. Martin's going to need to watch the video to further whatever prepare for his case. So are we setting this for a jury trial, bench trial, or a settlement conference?
Not clear about what you said about the discovery. You just said something about I can get it from the PD after an order, so I'm not clear on what you're saying.
What? Mr. Martin, all the knowledge that you have and you're confident in being an attorney, and you don't know what the fuck the judge just did for you? You need more information? I thought you were all knowledgeable about legal procedure and having a trial and being your own attorney. Let's see.
I can't tell you how to practice law, sir. So I can't tell you how to go about that. I'm going to enter an order for discovery.
Right.
And then you take your steps to get the discovery. All right.
So the order that I'd be given to it. If you're just going to tell me I can go to the records office and get it, that's not providing me with the information.
He provided you with the order and granted your motion. And now you don't know what the hell to do with it? Oh, come on, Mr. Martin. Throw in the towel. Admit you're a doofus. Come on.
I'm not telling you how to do it, sir. I'm just telling you I'm entering an order whereby you'll be able to get the gather information that you need to for your case. So.
All right, we'll just see when it comes in. But like I said, you're just not being totally clear on what's that going to be or whatever. But So I can't possibly object to it now. If anything, I have to wait and see what your written order says. But okay, because I doubt if I can find a jury of my peers, which would be.
Does anybody but me see what a doofus this guy is? He's asked the judge for something, the judge granted it, and now he doesn't know whether he should object to it or not. Is it just me, or is it Mr. Martin? Let's continue.
Those that who acknowledge as one of the people, sovereign people. Mostly everyone's probably, if not every jury member would say.
That's not how it works.
Okay, so Mr. Martin thinks the jury of his peers means clones, people that think exactly like he does. Nope, that's not it. Judge is going to explain.
But I'm just telling you, that's not how it works. You have to get back on Google and Google whatever other story you want to come up with. Peers just means anybody who's over the age of 18 who lives here in the city of Taylor. That's your peers who are also registered voters. That's where the jury pool comes from. That's what the Constitution allows for. They don't have to be, when you say like-minded, that doesn't mean that they have to subscribe to some archaic form of the Constitution that isn't how it actually reads. And I'm a pure constitutionalist myself, so I get that. But that's not what that's absolutely not what it means. Not to mention, I can't tell people, and I can't exclude people from a jury pool because what you're asking me to do is something unconstitutional. You will have a constitutional jury of your peers, as it has been declared by the United States Supreme Court of how that works. So are you requesting a jury trial or a bench trial? That's the simple question.
If I request a jury trial, would it be fraudulently presumed that I'm giving jurisdiction?
Say again?
If I say I want a jury trial, is that going to be fraudulently assumed by you that you have jurisdiction over me?
First off, I already established that I have jurisdiction over you. You committed a crime in the city of Taylor. I have jurisdiction over you. Court does. So we already discussed that part. You can order the transcripts from that first time when we already went through jurisdiction. If you didn't understand it from there, you can always order the transcripts and reread it. But clearly I already have jurisdiction. So, and I don't fraudulently assume anything. Everything I do is done because I was elected to be the judge here. I am sworn in as the judge here. I uphold the Constitution. Matter of fact, I keep a copy of my oath right here on the bench. Why? Because it means a lot to me. So there's nothing fraudulent about anything that I do, sir. I will tell you this: you will get a fair trial. That's for sure. That's why, because that's what the Constitution requires for everybody to get. And so if you're implying anything other than that, that's not going to happen. So again, jury trial or bench trial, I need to set it for one or the other, sir.
I object to the truth that you're asserting. I don't agree that that's true what you said there. But sure. If we're going to force the hand, like I said, it's going to be a jury.
All right, so jury trial it is.
But I'm
so I'll set that. Go ahead.
It's only through fraud and duress do I say that. So that's all I'm under here.
Okay. Well, first off, there's nobody, there is no fraud nor duress. You're sitting in your own home. You're on Zoom. There's nobody twisting your arm. No one's holding any weapon to you in order to necessitate a duress type of thing. And basically, I gave you a choice. Do you want a bench trial or a jury trial? So it was up to you to pick, and you wanted a jury trial. There's nothing wrong with that. You have a constitutional right to set jury trial, and we'll make that happen. So we'll be mailing out a copy of the scheduling order. Have a good day, sir.
I was say,
happy New Year.
You just talk. You don't give a person a respond, and then you say how something ain't threatened arrest, but you don't.
But when I make a ruling on something, a ruling is literally there's no response to it. That's what the ruling is. So the ruling is I'm going to set it for jury trial. Your motion for discovery is granted. I'm going to send out.
So what does Martin want to do? Does he want to appeal the judge's final order granting his motion to dismiss? Oh my God, this is hilarious. I hope you're enjoying it as much as I am.
An order for the discovery. And there's really no other response needed other than Happy New Year. You'll get your date in the mail for the jury trial, and you'll get a copy of the order in the mail.
that's clearly obviously unfair to say there's no response. That's saying what I say is that, and that's it. There's nothing to say about it. Obviously, you don't believe in the Constitution too much because you're not giving me my due process right to say what I have to say. Meaning, if
Well,
you
first
say
off, listen, if you're just gonna needlessly jabber about things that have nothing to do with anything of the case, you've already won your motion. So I'm not really sure what more you need to make a record on. I literally said, hey, we're gonna enter an order for discovery. You requested discovery by a motion, and I'm granting discovery. So there's really no more record to be made other than if you want to say something like, yay, I won, or something like that. But there's nothing more to add to that. If it's about the facts of the case, this is not the time or the place to talk about the facts of the case. That's what the whole point of a trial is for. And then you can prove your case to, well, you don't have to prove anything. The prosecution has to prove their case. You can present things or you can remain silent. You have the right to do that. You can be a witness for yourself. You can do that if you choose. So with regard to that, that's how we're going to proceed. And then, so we're going to send out again the jury trial notice in the mail, and you'll receive it at that point. In the meantime, stay safe, have a blessed day, and a happy New Year, sir.
Okay. Well, I'm not done yet.
Oh, he's done all right. He's finished. I hope you enjoyed this little quick one here. It's another funny thing for Mr. Martin to entertain us with. Appreciate you all stopping by. Subscribe if you want. Leave a comment. Let me know what you think about what people are saying and what people are doing in our wonderful courts. So, again, thanks for stopping by.